We'll hear argument in three cases this morning. First is 19-1108, Texas Commission on Environmental Quality versus Maverick County from Travis County in the Florida Court of Appeals District. Then 2309, City of Baytown against Schrock from Harris County and the First Court of Appeals District. And finally, 2517, U.S. Bank National Association versus Moss from Dallas County and the Fifth Court of Appeals District. The court has allotted 20 minutes per side in each of the cases, and we'll take a brief recess between the arguments, finishing them before lunch. The arguments are being webcast live this morning on the court's website and will be available later in the archives. We'll hear argument in 19-1108, TCEQ versus Maverick County.
May it please the court. Ms. Coy and Mr. Davis will present argument for the petitioners. Petitioners have reserved 4 minutes for rebuttal. Ms. Coy will open with the first 8 minutes. Ms. Coy will present the rebuttal.
Let me add also that Justice Lehrman cannot be present this morning, but expects to participate in the decision of all 3 cases. Let's go ahead.
Mr. Chief Justice, may it please the court. If I may, I'd like to focus my 8 minutes on the operator issues, and then Mr. Davis will address the issues the commission briefed. This appeal arises out of the renewal of a long-standing wastewater permit issued to my client or its predecessor since 1994. Interpreting its own rules and the extensive administrative record before it, the commission concluded that my client was the owner and operator of the mine for wastewater permitting purposes and renewed the permit. The administrative law judges reached the same conclusion. The Court of Appeals, however, concluded that my client was not the operator of the mine for these purposes, and instead our contractor was. There are 2 fundamental problems with the Court of Appeals' approach. First, it disregards plain text, and second, it disregards the deferential substantial evidence standard, which requires affirming the commission's determination regardless of which definition of operator you choose. I'll start with the plain text. There are 2 commission rules at issue here. In the first, the commission explains that for wastewater permitting purposes, an owner and operator apply, regardless of whether they're the same entity or not. Second, the commission sets a baseline definition of operator for these purposes as the entity responsible for the overall operation of the facility. Now, the commission could have chosen a number of different definitions of operator. The Railroad Commission, for instance, deems an operator anyone who removes a certain amount of coal from the ground. But the commission chose the word responsible, which means liable to be called on for, and overall, which means taking everything into account. The Court of Appeals erased these words from the rule and replaced them with personal performance, saying that by definition, always an operator can only be the entity who's responsible for its personal performance of causing the mine to function. Well, this risks sweeping in countless contractors across Texas who lack decision-making authority, are not responsible for overall operations, and that's directly contrary to the text, and it's directly contrary to the history and purpose. Originally, Texas only required owner permitting, with an explanation in the Texas Register that in this context of wastewater in Texas, it was often, the owner and operator were often one and the same, and it was often the owner who had the ability to effect change and ensure permit compliance. In the 90s, Texas took over the federal permitting system as well, and EPA had expressed a concern that when owners and operators were different, there could be instances in which the only permittee under an only owner permitting rule is an absentee landowner who has no involvement in any way in operations. And so what Texas did here was quite reasonable. They said, okay, we are going to permit the owner and operator. If they're one and the same, great, we're covered. And if they're different, then we have the owner. And even if that happens to be a completely absentee owner who just owns the land and is wholly uninvolved, we have the person responsible for overall operations who can effect change and ensure compliance with the permit. Well, when you look at that text in history, there's no question under the substantial evidence standard that we sail over it. The Commission issued findings of fact 40, 41, and 42, all of which were well supported by the testimony of the president of my client, the president of the contractor, and the contract itself. Look, for instance, at contract provisions 3.3, 5, 7, 8.1, 8.6, 9, 10, 12.5, and 26, and 16. What all of these show, along with the testimony, is that no operations happen on this line without my client. We are the ones who determine the amount and quality of the coal to be mined. We have to approve every plan and budget before action can be taken. Every plan includes the design plans, the life of the mine plans, the annual mining plans, and as 8.6 of the contract makes clear, along with the testimony, the contractor lacks discretion to depart from these plans that we have approved. We have the ultimate say in whether subcontractors will be hired. Over inventory, we have ultimate financial control, but that financial control on this record is linked to operational control. This isn't just a record that shows that we own some land and are wholly uninvolved along the lines of where EPA expressed concern. Our financial control, as Mr. Cost testified, is directly linked to operations. We oversee permit compliance and have responsibility for it. And so, looking at
a couple of points that you might address. Number one, Camino Real, the contract says that they're being hired to operate, right? Construct and operate the mine. And number two, didn't your client, when it applied, it had the option of choosing owner, operator, or owner and operator, and it chose only owner, which seems to suggest even your client didn't think it was the operator at the time of the application.
Absolutely, Your Honor. So first, on the contract saying operator, it says that we hired them to operate the mine pursuant to the terms of the agreement. We read the contract as a whole, and when reading it as a whole, it makes clear that they only operate under our direct approval. They can't do anything without us. So when you ask who is responsible for overall operations, even under the Court of Appeals' interpretation, we sail over the substantial evidence standard because we're still, the buck stops with us for our personal performance. Without us, this mine can't function. But they cherry-pick provisions of the contract, but read as a whole, the contract supports us. And in any event, the substantial evidence standard says you look at the whole record, and there's evidence and testimony supporting us as well, certainly more than a scintilla. To your second question, Your Honor, of the checking the box. Number one, if you continue on in the record of DR 107, they reference a 2-page form. Well, right after that is our actual application. And in the actual application, we identify ourselves as the owner and operator, the only permit applicant. Number one. Number two, this court has determined in Denbury and Court of Appeals determined in Heritage that a mere checking of the box is not conclusive of your legal status. Number three, it is for the commission to determine who qualifies as an operator for these purposes. And number four, this all comes back to the deferential substantial evidence standard, and at most, that could be some evidence in their favor, but it certainly isn't conclusive, and I see my time is up, Ronald. Thank you. If there are no further questions,
Any other questions? Thank you, Ms. Cole.
Thank you.
We'll hear from the commission.
Thank you, Mr. Chief Justice, and may it please the Court. I'd like to focus my time, if I could, on two of the questions that the Commission presented. The first is whether the Court of Appeals' conclusion on the owner-operator point that Ms. Coy just discussed deprived the courts of jurisdiction to reach the other challenges to the Commission's order. And the second is whether the Commission's modification of the SOA judge's proposal for a decision was authorized by statute, and whether the general APA standard or the specific TCEQ standard governs that amendment. So on the first point, it's not entirely clear why the Court of Appeals thought that its reasoning deprived it of jurisdiction. That part of the opinion is just a single paragraph right before the conclusion. And APA section 2001.171 allows for any exhausted issue to be raised in judicial review, and 2001.174 allows a court sitting in judicial review to consider all of those issues and affirm in whole or in part, remand, reverse. Subsection 2 gives it a laundry list of options for bases to take any of those actions. It might be, as the respondents have suggested, that the Court of Appeals thought that the owner-operator point was just a fundamental part of this case, such that its conclusion on that point vitiated everything. But that's not the case. The point about who the permittee is, or who the owner or operator is an administrative part of the application. It doesn't have anything to do with what the agency calls the technical part of the application, which is the substantive water quality-based determination of what's within the core of the Commission's responsibility as protecting water quality. And all these other issues go to those distinct questions: anti-degradation review, boron and aluminum, chronic effluent limits. All of those are completely distinct from the owner-operator issue. And these permits are facility-oriented. And what I mean by that is that once a permit is granted, it can be transferred. And the Commission's rules on that appear in Section 305.64. And so, if it were the case, we think this Court should, of course, disagree with the Court of Appeals on owner-operator, but if it agreed with the Court of Appeals on that point, the matter could be remanded to the Commission. The Commission could reopen the record under 2003.047M, and there could be an amended application that includes an operator, and if this Court concludes that's what's needed, and that would not affect the rest of the record that's currently before this Court. And we're asking this Court to reach those other issues in the first instance, even while recognizing that the Court typically doesn't do that. It would typically remand the Court of Appeals for that determination.
Before you get to that, Mr. Davis, I just want to be sure I understand your point. If we agree with you that it's not a jurisdictional problem and that the Court of Appeals could have reached those issues, are you saying it was an abuse of discretion for the Court to decline to reach those issues, even if it's not jurisdictional, or did they have the option not to reach those issues?
I suppose the Court of Appeals may have had that option, Your Honor, but as part of judicial efficiency, it should have done what the trial court did. Otherwise, we would have a system where issues would bounce between the Commission and the courts, maybe even one issue at a time, because the courts would think that their decision deprived themselves of jurisdiction somehow to reach the others. That's just not how the system is set up, and it would prolong permitting in Texas substantially.
If it's undisputed that a facility has both an owner and an operator that are two separate entities, and one of them files an application just in the normal routine process, is TCEQ going to proceed, or are they going to require the other one to appear?
So that would be within the Commission's jurisdiction because there is an application on file. And whether the Commission would say, well, let's just hold off, let's make sure we have an operator on here now, or if it would proceed further, I can't answer that. But of course, the statute does require, and the rule requires both the owner and operator to be on there.
Right, so isn't it kind of a standing issue? Because if there's an owner on the application, but it's undisputed that there's a separate distinct entity that is the operator, the decisions that are made on anti-degradation and all the other, they're going to be binding on that operator, even though they're not present to participate in the process.
That's correct, Your Honor, I believe, but again, it's something that could be fixed through a permanent amendment, and that's why I'm saying it didn't deprive the courts of jurisdiction to allow that to happen if the court were to conclude that DRCP is not both the owner and the operator. I see I have just a couple of minutes left, and if I could, I'd like to touch upon the second issue I mentioned at the outset, which is the Commission's authority to modify a proposal for decision. And there are two different statutes that are in contention here. One is the General APA standard in 2001.058E. And then our contention is that instead of that provision, 2003.047M controls here, because that is the specific provision that governs the Commission's authority to alter a proposal for decision. And we know from subsection N of that provision that to the extent of an inconsistency between 047 and the APA, 047 controls. And here, 047M provides a complete set of instructions to the Commission in particular that's different from the set of instructions provided in 058E, which is more limited. 047 allows the Commission to make any changes it wants as long as they are based in the record, and it provides an explanation of the basis for its changes. And that final requirement essentially would duplicate the final sentence of 058E. And that's, I think, a good indication that these provisions can't be read in tandem, because that would require rendering part of one or the other superfluous. And the Commission here satisfied its burden under 047M and 058E too, if the court conclude that applies, through its explanation of changes. That's on pages 16 to 18 of the Commission's order. And there, the Commission explains why it made the change with respect to boron and aluminum. It cites the record, including the implementation procedures, Mr. Matzner's testimony about groundwater, the new data that DRCP supplied in September of 2015 about the outfalls. And so it survives that review. I see that my time has expired.
Any other questions? Thank you, Mr. Davis. We'll hear from the respondent.
May it please the court, Mr. Frederick will present argument for the respondents.
Good morning. May it please the court. My name is David Frederick. I am appearing on behalf of all of the respondents. We have two governmental entities, two advocacy organizations, 5 individuals who live somewhere near the line who have participated in proceedings to this date. I have prepared and handed out this morning 5 exhibits, which I want you just to know what they are. If we get time to come back and talk with them about them, I will be happy to. But the first two, exhibits A and B, those relate to TCEQs. Those are TCEQs. The first 1990 acknowledgement that it was acquiescing to EPA and requiring that an operator be an applicant for a permit, either somebody bound by the permit. Exhibit B is EPA's understanding from 1980, and therefore should have been TCQ's understanding in 1990 of what EPA wanted by requiring an operator to be on the permit. So what were the characteristics of an operator that EPA wanted that TCQ was trying to, in 1990, comply with? Exhibit C is the answers that TCQ gave us to interrogatories in the course of the litigation, and which were submitted into evidence as part of the record, demonstrating that in 2015, when the interrogatory response was made, TCQ was operating under a different definition, a different understanding of the same definition, I should say. This is when TCQ makes it clear to us that it considers only people with financial responsibility to just not consistent with what happened in 1990 and with what EPA said it wanted in 1980. The fourth exhibit is from an old case. Well, it's an old case, but not just any old case. It's Texas Railroad Commission v. Schrock. This is this court's first statement of something having to do with the mere scintilla issue, unsubstantial evidence review. If you track back any case that this court has addressed in the past, 5-10 years, you will see that they pretty much all track back to, and raise the scintilla issue, track back to Texas Health Facilities Commissioner, I believe it is, versus Charter Medical Dallas, and in that case, cites a few cases back upstream. And if you look, I have excerpted at the end of Exhibit D, I have excerpted what we the respondents consider to be the critical language, but certainly have excerpted language that the court used to explain its understanding of the substantial evidence rule and the scintilla issue as it is related to the substantial evidence rule. It's the court's first statement certainly first statement of anything to do with scintilla, and it's a very, very good statement of what the substantial evidence rule is. 1942, so it's an old case, but it's a thoughtful case. So that's Exhibit D, I guess it is. And then Exhibit E is just the control structure of the owner, the RCP, as explained to us in the trial, and that structure bears on one of the several reasons the county really wants to have the operator be the person on the permit, bound as you would be to a contract, because as that control structure demonstrates to you, I think, getting your hands around the RCP, if that becomes necessary, will be difficult. Let me say first, I think that the Court of Appeals correctly decided what is the legal standard that applies to the person who applies to who's going to seek the permit. So the Court of Appeals opinion says, okay, let's figure out what's the definition of operator. Then let's go figure out whether there's substantial evidence to support that definition, support DRCPs having complied with that definition. That's not the way the briefing to you has come from the petitioners. The briefing to you from the petitioners has just fired off right off the bat, as all people who were trying to reinstate an agency decision do. They say, oh, well, there's not substantial evidence. There was substantial evidence. And after all, substantial evidence is a pure scintilla. It's just some trivial thing better than nothing. I don't think that's the right way to look at it. I think the right way to look at it is let's have a definition of what an operator is. That's what the Court of Appeals did. That's what the Court of Appeals did in Heritage on San Gabriel Homeowners Association a few years ago.
Why should we look anywhere for a definition when there's one right there responsible for the overall operation of the facility? Isn't that the definition? I mean, I think what the Court of Appeals said, which I believe to be true, is yes, that's clear. There's nothing there about financial control. Why do we need the rest of the gloss from Heritage if we've got a definition right there? Because now in two cases, somebody has said that's not straightforward. I mean, the Court of Appeals has said twice now, this is not ambiguous. This is what this phrase means. Two other people, corporations, have said otherwise. So, you just don't keep arguing. We shouldn't litigate it over and over and over again. But that's why the Court of Appeals lines it all out. All of us think of an operator as somebody who physically does something. I mean, you've got to be turning the valves, lifting the switches, running the equipment, whatever, to be an operator. And I agree with you, Mr. Justice, that it doesn't seem that complicated to me, but clearly there are other smart people who disagree. Well, the word responsible may have some meaning here to potentially distinguish between just the guy whose job is to flip the switches and the guy who's responsible for ultimately for making sure that the switches are flipped. Well, but as you've seen from the Court of Appeals opinion, maybe from the record, the RCP, the owner, has almost no authority on the site. It can act, it can demand action in the case of an emergency. Well, we could all, of course, just argue a lot about what's an emergency. But except for that, the RCP can't do anything on the site. So, I mean, I find it hard to believe that people would think
dispute over the definition or the application of the definition to the facts here? And if it's the latter, do the courts owe some deference to the commission's determination? And since the commission determined that the contractor was the operator in the heritage case, but has determined in this case that the owner is the operator, are both of those decisions, although they go different directions, are they due some deference?
I think because the only reason we do deference is if the definition of operator were ambiguous. We don't think the definition of operator is ambiguous. So, separate from the substantial evidence question, sure, the agency gets the benefit of substantial evidence review, but we don't defer to its interpretation of some statutory or regulatory term unless that term is ambiguous. And as the court has said, this one is ambiguous. So let me turn to the substantial evidence question.
Before you get to that, can there be more than one operator? And what happens if there is? Do all of the operators have to apply, or is it enough if one applies?
I think you have to have the overall operator.
So there can only be one.
I would say there can only be one. I believe overall operations is the term of art that's used in 305.224. So I think overall, so the general contractor, so to speak. But let's be clear, we don't really have much problem with that in this case. We've got one very large general contractor, a subsidiary of North American Coal Company, a huge company. There'll be some people come on to test some water or something, but there's not going to be any real dispute about who's operating the place. Give or take the dispute about whether the owners operate the place because the owner supplies the money.
So if there are factors pointing both ways about who's doing the overall operation, and there can only be one, then what is an agency to do at that point?
Right, the agency has to make a decision. The agency should make a decision using the proper definition of operator at the time that the permit is issued. And if the person who thinks he or she is an operator doesn't like that decision, or the person who was decided was defined to be an operator doesn't like that decision, then that person or entity has the same power that anybody does in these contested proceedings. You go off to district court and contest it some more. And
so wouldn't that mean that if there's a scintilla of evidence pointing each way and the agency picks one, then the court doesn't get to second guess that as to who the operator is?
No, good. May I move on now to substantial evidence? Because that's what I think is, the main useful thing I think to come out of the opinion from this court is a restatement of what the substantial evidence rule really is. It is not. It is, as the court said back in 1942, it is not unacceptable. It is only really starting with about Charter Medical Dallas case that people began to talk about only anything more, any little increment more than a scintilla would be enough to support the agency decision. Prior to that time, the cases say things like a mere scintilla is not enough to support the agency decision. So they don't really say, the cases don't say, the mere scintilla is all you have, or one increment more than a mere scintilla is all you have to show. The cases say, a mere scintilla is not enough. People have loosely said, oh, well, more than a mere scintilla is enough. Well, that's not true. There's a big gap between a scintilla of evidence and substantial evidence. Well, there could be a big gap between a scintilla and substantial evidence. And that's what's so good about the 1942 of the Brewer Commission v. Shell. We sustain, so looking back at I'll read you what I consider to be important parts, but you and your staff can give you. We will sustain the agency's order if the conclusion is reasonably supported by substantial evidence. This does not mean that a mere scintilla of evidence will suffice. So that's the first time this course has ever talked about mere scintilla. The mere scintilla of evidence will suffice. Nor does it mean that the court is bound to select the testimony of one side with absolute blindness to that introduced by the other side. After all, the objective is to do justice. The record is to be considered as a whole. Well, that is, of course, the same admonishment or the same instruction that we get from the APA itself. It's the credible evidence in the record as a whole that we look at. So, much of the briefing in this case has suggested that the Court of Appeals erred and the respondents are just mistaken because we would go in there and re-weigh the evidence that the agency has already weighed. But there is supposed to be judicial at least review of all the evidence that everybody has submitted, not just the evidence that is favorable to the agency and favorable to the RCP. And I think that has tended to get lost in recent years. The opinions from this court, Judge Lerman had an opinion in Aleman, I'm pronouncing it Aleman, the Texas Medical Board back in 2019. Justice Boyd had one here in PUC versus TIC this year, back this spring, both of which ultimately refer back to they refer to cases that in turn refer to either Dallas Charter Medical Dallas, or to the case to which that case referred, which is Torchy, Royal Commission, Torchy or Torcho or something of that nature. And those cases, once you follow them back upstream, those cases are pretty strong on the need for the court to look at all the evidence that was out there, and then the court gets to decide, could reasonable people, agency, have reached the decision it reached, given the breadth of evidence, all the evidence from both sides that was out there. So, anyway, I thought that Court of Appeals opinion was really well thought through, logical, and I do think it's just not reasonable that someone would think.
Let me ask a question from someone that just doesn't know this area of law. What does it matter? Why does it matter whether this contractor is on the application? Not the owner. Clearly, the owner and the one who is ultimate. I mean, I know we've got to construe the rules as written, and if the statutes and rules say it matters, but I'm just trying to figure out, when you've got the owner here who has overall responsibility, at least financially, for the property, and what difference would it make? I mean, if the permit is granted and it has these conditions and requirements, they're going to be binding on this contractor, whether the contractor technically qualifies as the operator or not, right?
Well, no, I mean, that's not clear that they would be binding on the contractor.
So the contractor can violate the permit?
It's binding.
Look, he should violate the permit, but I mean, you're not going to be able to control that by the contract. TCEQ could come out there, could probably come out there. I mean, again, it's like a contract. It would be better, I guess, it's like a contract. TCEQ would find it easier sledding to go against the operator if the operator were its permittee. If the operator is not its permittee, if the operator is just some other individual out there, TCEQ, depending on the nature of the violation, can go after that.
But if the owner is here, the
RCP. Those Republicas Coal Partnership.
Yeah, so DRCP is the owner. Its property, which it has contracted with Camino Real to develop and operate, its property is now subject to all of the conditions and requirements of this permit. The Camino Real may not be, technically, but they certainly are subject to the oversight of the owner with whom they've contracted. So I'm just trying to figure out why in the end this matters to your clients as opposed to this just being a technicality that you can hold all this up.
What is the most directly matters to my client? My client has enforcement authority. Counties have enforcement authority of TCEQ permits. It would like to have the shortest, most direct path possible to enforcement if enforcement becomes necessary. Secondarily, the applicants for permits have to have their compliance histories developed and presented to the public, and not theoretically, and they may be litigated, or the truth of them or the consequences of those compliance histories may be litigated in these contested proceedings. Right now, Fuels we know nothing about its compliance history. The administrative law judge refused to require it to be prepared, said it was, testimony about that was not relevant because there's no law requiring non-operators to have their compliance histories prepared. We don't know what the compliance history would be, but according to the testimony at trial, the compliance history of Camino Real Fuels will be developed in light of violations and complaints and whatnot from its sister companies, of which there are probably 20 or 30 in this country. Oh, I don't know how many. There are many of them in different states. And its parent company, North American Coal Partnership. So that's the testimony of one of the RCP's witnesses. If we had all that information, then perhaps because the compliance history allows TCEQ, if the compliance history is not good, the compliance history allows TCEQ to impose limitations on permits that TCEQ either doesn't want to impose normally or possibly legally is even prevented from imposing normally. So in our particular case, there's this argument, which the county didn't much participate in, but it's a valid argument, that there should be a permit limit on burial in the wastewater discharge. TCEQ struck that from the examiner's recommendation and said, no, we're not required to do that, we're not going to do that. Whether it would have done that in the situation where the compliance history of the operator had been shown to be inadequate, that's another question. That's something the county, in this case, the local landowners, might really have prevailed on. There's another one about monitoring for lumen discharges in the wastewater. TCEQ said, no, we don't even have to monitor. Well, clearly, there's some history of TCEQ having a permittee with a bad compliance record being subjected to increased monitoring. So, anyhow, those are the main reasons. I mean, we've got a park downstream from this mine. We'd like to make sure that we know as much as we can about whoever it is that's going to be making decisions that affect wastewater discharges that flow through the park. But those are the two main reasons that I believe might motivate my county on this. Let me turn real quickly to the issue that Mr. Davis raised about 2001.058E versus 2003.047M. Under one controls the other. Our position is that they are not inconsistent. They can be interpreted together. But quite honestly, I know you've had pending before you on the petition application now, I bet a year. This Dyer v. Texas Water Commission, the TCEQ case, that's a great big issue in that case. Lots of folks have weighed in on it. I saw a brief come in the other day from Professor up at Baytown, Ron Beal. So is our position that the opponents are correct, that these two sections can be considered together. But I honestly think a weighty decision in that case would just be a better use of everybody's resources. I think they would have briefed it better than we are, certainly than TCEQ has thus far.
Any other questions? Thank you, Mr. Frederick.
Thank you.
Thank you, Your Honor. I'd like to address a few quick points. First, counsel for respondent says an operator is always the person who's turning the valve. Well, that's not true. It depends on the applicable text. The United States Supreme Court, in addressing the CERCLA context in Best Foods, directly rejected that view. The explanation from the EPA of operator that he points you to refers to controlling operations. Now, of course, there can be different definitions. Where I started, they put a lot of emphasis in their brief on the Railroad Commission's determination that the contractor here qualified as an operator. But the Railroad Commission deems anybody and everybody who removes a certain amount of coal from the ground an operator. What matters here is the applicable terms, responsible and overall. Second,
is that how you distinguish the Heritage case? Because in that case, the commission determined that Waste Management, the contractor, was an operator. And so is it consistent with the commission's application in this case to say that the owner was the operator?
The difference.
And what is the difference in these two cases that make the commission's applicable standard seem reasonable?
number one, the deference to the commission there was correct, and the ultimate decision was correct because there, the person on the permit was the one who was responsible for overall operations in all ways. So however you looked at it, they got it right, but what Heritage got wrong was to the extent it said that operator by definition can only mean person responsible for its personal performance of causing a mine to function. That's simply not what it said. Now you can distinguish it on the basis that who has to apply for one permit isn't necessarily the same as the other, but really what controls here is the applicable plain text. And the plain text is...
But what was the difference between the operator in this case and the operator in the Heritage case, not looking at what the Court of Appeals did, but what the Commission did?
Absolutely, Your Honor. When you look at what the Commission reasoned in that case, they looked at who was actually controlling overall operations. Once again, this comes back to the notion that you can have an absentee landowner. You can have a situation where there's somebody who owns land but is wholly uninvolved. And there, in that case, Waste Management was the one who, at least when deferring to the Commission under the substantial evidence standard, there was more than a scintilla of evidence supporting the notion that they were the ones who controlled overall, were responsible for overall operations, which the same thing here. You look at who on this record, with the very deferential substantial evidence standard, meets the plain text definition of responsible for overall. And here, you asked, who can you enforce against? The evidence shows DRCP had a local office, somebody on site daily, and we signed the permit. You can enforce against us. And the contract and the testimony shows we could fire the contractor. We were the ones who were responsible for overall management, overall operations here. We set the amount of coal to be mined and the quality of coal. We made all the determinations and approved all the plans. Just as you, as a judge, are responsible for your overall opinions, even if your law clerk might assist you, my client, at least there is far more than a scintilla of evidence in the record that shows, was responsible for overall operations. I'd like to briefly touch on the substantial evidence standard, and Justice Bland, you explained it very well in the Review case, but you cannot, as the APA says, reweigh the evidence, and City of Keller provides helpful context in the very rare circumstances in which contrary evidence can even be considered, none of which is relevant here.
Any other questions? Thank you, Ms. Goy. The case is submitted, and the court will take recess.
All rise.
Please be seated. We'll hear argument in 2309. City of Baytown and Schrock. Justice Lerman cannot be present this morning. Expects to participate in the decision.
May it please the court. Ms. Killian will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal. May it please the court. This is not a takings case, no matter how much Mr. Schrock tries to make it one. This case is part of a growing trend of cases where property owners try to frame their claims as takings claims in order to overcome governmental immunity in cases that do not involve direct restriction on property use. This is especially true for claimants like Mr. Schrock, who really just have negligence tort claims and cannot overcome their immunity, governmental immunity under the Tort Claims Act. This distinction between negligence and takings claims was clearly made by this court in the City of Houston versus Carlson case, where the court said a mistake is a claim of negligence, and negligence is not a taking. Mr. Schrock's counsel explained in his opening statement at trial what this case is really about. He said, and I quote, "The City of Baytown made a mistake. The evidence is going to show they actually made several mistakes, and Mr. Schrock has been harmed by what happened." What happened was that Mr. Schrock did not like the utility bill, and instead of paying it and seeking a refund for what he believed he didn't owe, he abandoned his property and allowed it to waste away for nearly a decade. He wants the city to compensate him for the waste that he allowed to occur in his decision not to rent his property. That's not the way takings law works, and the Court of Appeals erred in holding that these facts could constitute taking. To overcome immunity for his negligence claim, Mr. Schrock would have needed to allege and establish a valid waiver under the Texas Tort Claims Act, which would have required him to show that the city caused his damages by use of motor-driven equipment or a motor-driven vehicle. He hasn't made those allegations. Because municipalities' liability is so limited under the Tort Claims Act, claimants have an incentive to try to plead their claims as takings claims. Most of the time, courts can determine that the claim is not really a taking and dismiss it. But in this case, the Court of Appeals really lost sight of what takings law is about. There are two types of takings. There are physical takings and regulatory takings. Physical takings are easy to recognize because they involve some kind of physical occupation by a governmental entity or physical appropriation or possession of property. In those cases, compensation is categorically required. We don't have any appropriation of property here. We don't have physical occupation. So
does the placement which which restricts potentially the ability to sell or transfer the property, does that constitute the type of conduct that could be considered a taking?
Thank you for that question. I don't think so. I think traditionally the physical taking is going to be a physical possession of property, physical occupations, kind of like flooding or some sewer lines, things like that are physically at the property. A lien is not a physical restriction. In this case, Mr. Schrock doesn't really challenge that anyway. He challenges the placement of the lien, and he challenges the withholding of the services, but based on the city's mistakes, which makes it rooted in negligence.
Well, a zoning ordinance is not a physical restriction either, but that can be a taking. So could a city just rewrite its zoning ordinances to place liens and thereby say that there wouldn't be a taking in those cases?
I'm not sure, Your Honor. That's a good question. Here, there's just a zoning ordinance is a land use restriction.
Okay, but what if the city said, if you try to use this for any other purpose, a lien is automatically placed on your property and you can't dispose of it?
I think that would be going into whether that would be an unreasonable land use restriction, and you would go through the factors.
I thought you were saying a lien is not a land use restriction.
A lien is not a land use restriction in a physical sense, a physical taking.
Right.
Right. So if we're talking about a land use restriction, I'm sorry.
Can it be a regulatory taking? I took it your position was it can never be a regulatory taking, and so I'm trying to understand if under some circumstances a city could use a lien to effect a regulatory taking, and if so, where that line is.
Okay. I don't have an answer for you on that right this time. I think your question is going to whether the ordinance itself is a land use restriction. And it isn't the city's intent when it passed the land use, the ordinance in this case wasn't to regulate land use. And so we are missing those elements of intent and public use. That there are the three elements of a taking in Texas, intentional act that causes a taking for public use. And those elements of intent and public use are inherent in land use regulation like a zoning ordinance because it shows that the city clearly intended to restrict the use of property. In this case, what we have is a utilities ordinance that doesn't show any intent by the city to restrict his use of his property. He can still rent his property. He can still.
Wouldn't that turn taking into an intentional tort claim, though? I mean, we said in the Rowlett case that in a regulatory taking, it's the passage of the ordinance that injures the property's value or usefulness. Isn't that all that's required to be shown?
Yes, you are correct. So what I was getting at is when it is a land use regulation, the intent and public use elements are clear because it's clear the city intended to restrict the use. But my point is that this is not a land use restriction because it was a utilities ordinance where the city was setting forth a process for collecting on outstanding utility bills. The overall intent behind it was to try to keep costs down for the public, which would, many outstanding bills like that over time is going to cause the cost of utility bills to go up. So the intent behind the city's ordinance was not to regulate the use of land, but to set forth a process for collecting those outstanding bills. And under Carlson, where the property owners of Carlson challenged the city's process for getting the repairs and the certificate of occupancy for the condominium, this court said that challenging a process or procedures that a city puts in place is not a challenge of a land use restriction. It is.
But isn't he also challenging the underlying ordinance in this case, unlike in our Carlson case?
Well, I don't think he was challenging the actual ordinance itself. He had a declaratory judgment claim that where he wanted to ask the court to invalidate the ordinance. And again, it's not a land use restriction anyway. So even if he was challenging the ordinance itself wasn't intended to restrict the use of land. So if we open up the door to allow any kind of something that tangentially affects property use in some way, we could arguably be allowing takings claims in situations where a dump truck causes damage by slamming into the property, which we know wouldn't be a taking, but it would affect the use of property. It would damage the property, but that in and of itself isn't enough.
But if a dump truck is parked to block all access to the property, even temporarily, that could be a taking, regardless of whether it was parked there intentionally, right?
I think that gets into the Tort Claims Act a little bit because you're talking about intentional acts, and intentional acts are, the Tort Claims Act says that intentional torts are, the government is immune from intentional torts. So intentionally doing something when you're looking at, or I guess it could be a
I was just picking up intent from your test. So I guess I understand the concern that we could sweep too broadly, but I'm also wanting to be sure that we don't write a rule that allows cities to circumvent the constitutional restriction on requiring compensation for takings by recasting what they're doing as a lien, and then requiring some sort of inquiry into intent that it's not clear to me how you determine intent.
Okay. I think the first thing that we should take from that is, again, the three elements of a taking are intent, an intentional act that causes a taking for public use. So when a city passes a zoning ordinance to restrict the use of property to only commercial use, it's clear that they are intending to interfere with the use of property and place a restriction there that the property can only be used for commercial use. When you have a utilities ordinance where the city is setting forth a process for collecting outstanding bills, that's not an intent to regulate the use of property or access.
You said earlier that intent, it's the act that has to be intended. So what cases shed light on what the intention was? And I assume the city intended to pass the ordinance and intended to place the lien. Are there any cases that shed light on what intent beyond that is required to have an intentional act for the takings purposes?
I'm sure there are cases where I didn't bring them here today, but I can certainly present them to you later today if you need to.
You said that the remedy that Mr. Schrock had was to seek a refund. And I'm wondering, because your position is that the claims he would have brought for negligence are immune, how would he have affected remedy? Because the city, I think, concedes that the ordinance and the lien were improper. So how would he have affected that remedy?
Thank you for that question. Well, he did appeal the amount of the lien, and he went through that administrative process, and the city reduced the lien, and then he just, again, abandoned his property. He didn't do anything about it. The remedy...
Once he lost the appeal, or he partially won the appeal, but still had some utility bill to pay, did he have further remedy that he could seek?
Well, he could have sought an appeal from that decision through the city's administrative process, which he didn't do. He could have paid the bill and sought a refund at that point, which I think would have been a reasonable route to take. He admitted that he had the funds to pay it. It wasn't a very big bill. He tried to go pay it twice, but he decided he just didn't want to pay it and just wanted to abandon his property instead. I think that it sets a dangerous precedent to put all of that decision, whether something's a taking, this choice to abandon your property and make expand takings law beyond what it is and allow this causation element to be affected in that way. I mean, it certainly wasn't foreseeable that he would choose to boycott a bill and abandon his property for a decade because he was angry about it. And I think that goes to another element that he's missing in his takings analysis, which is his causation element.
Is the precedent on unconstitutional exactions apply here?
It doesn't apply. An exaction is when it has to do with development of property. So when a property owner wants to develop property, they go seek a development permit from the city. The city, if it is an exaction, would say, well, we're conditioning the granting of the development permit on you granting some public access to the property or something like that. And the courts have said that it's a way of the property owner would have otherwise be entitled to the compensation for a taking, and it's usually physical taking. But in giving up that compensation, they would be granting some kind of public access. The famous Nolan and Dolan cases where the property owners had to grant a walkway path for the public to walk through their property in exchange for a development permit. And so the court goes through an analysis there about whether or not they can do that, whether they can condition a development permit. But exaction cases they don't apply outside of the development context, or they haven't. I have only a minute or so left on my time here, so I just want to touch on Carlson very briefly. So again, Carlson, the building official for the city of Houston, he told the property owners of condominiums to repair their property or and obtain the certificate of occupancy. The building property owners decided not to do that, and the building official ordered them to vacate. The property owners sued for taking and argued that the order to vacate was a taking and that it was based on mistake that he issued the order to vacate. Here, Mr. Schrock is challenging the lien, he's challenging the withholding of services, and he's saying that those things were issued against him and withheld based on the city's mistakes in applying its own ordinance because it knew or should have known that he was renting the property and mistakes in applying state law. And this court held that those things don't amount to a taking, that the process or procedure that was involved doesn't amount to a taking. You have to challenge a land use regulation. A land use regulation is, again, easy to spot as far as whether it's a taking or whether you engage in an analysis of a taking, because it clearly shows that the city or the governmental entity intended to regulate the use of property, and we just don't have that here. There's no clear intent. And at that point, I need to reserve the rest of my time.
Any other questions? Thank you, Ms. Gilliam. We'll hear from the respondent.
May it please the court, Mr. Musamichi will present argument for the respondent.
May it please the court, my name is Rob Musamichi, and I'm here to represent the respondent, Mr. Alan Schrock. The Court of Appeals held that it was reversible error for the trial court to grant directed verdict against Mr. Schrock on his regulatory takings claim, and this court should affirm, because the evidence at the trial court raised the material fact issue on each element of the regulatory takings claim, and material fact issue on each element was raised on the material element of the Mayhew Penn Central balancing test. The standard of review is de novo, and the directed verdict should be sustained only if there was no evidence more than a scintilla on each of the viable facts. The Fifth Amendment and the Article 1st, Section 17 of the Texas Constitution point out that no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. I love this case. I mean, Penn Central in 1978 pointed out the importance of the Fifth Amendment to private property rights, where they pointed out that the Fifth Amendment guarantee is designed to bar government from forcing some people alone to bear the public burdens which in fairness and injustice should be borne by the public as a whole. And with all due respect to my counsel on the other side of the aisle, what she pointed out was literally that the purpose of the city was to keep costs down due to the outstanding bills of some of the tenants that were not paying. And so they basically came up with a scheme to make some persons pay for all of those unpaid and uncollected water bills. So that actually is what was in the Pennsylvania Coal versus Mahan case. I mean, think about owning a house but finding out that you don't have rights to the surface of the dirt below your home. And so the Pennsylvania legislature decided that they were going to create a law that would allow the coal company to have the property rights below the earth of your home, and that property right, regardless of how much value it was, would be superior to the rights of the house. And so that they could extract the coal, even though that your house might become falling into the pit.
So the counties and school districts and other government entities, they collect taxes. And when the taxes go unpaid or there's a dispute about the amount of payment, counties place liens on property. If it's ultimately determined that the county was incorrect in levying the tax or that the amount of the tax was incorrect, is that enforcement, does that constitute a regulatory taking?
Well, Your Honor, I don't know the answer to that, but let me explain why I think that what happened here in the city of Baytown is different. Because what they did was they introduced a regulation that didn't affect Mr. Schrock's actual liability. They enacted a regulation that created a scheme by which the debts of third parties would be Mr. Schrock's liability.
He as the owner was to guarantee payment of the utility bill by its tenants.
But that was,
and it was not in accord with state law. I understand. But if a county levied a tax that was not in accord with state law and did all the same things that the city did here, would that constitute a regulatory tax? I'm just trying to understand how any improper enforcement of an improper ordinance, how that wouldn't turn into, I mean, it seems like under that theory, anything could be taking?
Well, under the Penn Central factors, let me go down to Penn Central factors, which were still followed in this court's opinion in Mayhew. And because in the Penn Central, they found that it was kind of hard to find. It's an ad hoc analysis. But following Pennsylvania Coal and Mayhaw, if the regulation goes too far, is the analysis. If the regulation goes too far, it's a taking. And so we found that if the economic impact of the regulation on the claimant is one of the factors, the extent to which the regulation has interfered with the direct investment-backed expectations of the claimant, and then the character of the government action. So in your analysis, or your hypothetical, the character of the government action really is valid, that there is a legitimate interest in collecting taxes. So I would submit that in your hypothetical, it is a legitimate point for the government to collect taxes, ad valorem taxes, that have been unpaid. So it perhaps would not reach so far as to be unreasonable for a government or a county to assess a lien, or to place a lien for a legitimate purpose of collecting an unpaid ad valorem tax.
Well, I think the question, though, is there are all kinds of reasons why a lien for utilities or for taxes or some other lien the government might impose could end up being invalid. And is it always the case that if the lien ends up being invalid, whether it's illegal or there's some other technical defect or whatever, then the consequences of the lien having been imposed are a taking?
I think, Your Honor, the idea of the lien itself is important in this case, but we have to really come back to why, or to the analysis of the balancing test itself. Because there's, under the takings law and the jurisprudence, the first step in the analysis is whether there's a physical invasion of the property. For example, under the Loretto case, U.S. Supreme Court in 1982, the teleprompter, the cable companies literally placed, allowed for the placement of communication devices on top of an apartment building against the owner's consent. So that's a physical invasion. That's a physical taking, clearly deemed per se to be a physical invasion and deemed to be a taking. The Lucas case in 1992, where they disallowed the use, there's no economic use whatsoever. And then we move into where in Lingle in 2005 point out that if we don't have one of those two scenarios, then we follow the Penn Central standards, which is exactly what this court did in Mayhew, with the additional, of course, and there was written by Justice Abbott, now Governor Abbott, on behalf of a unanimous court, which also included an additional component, the substantial advancement of a legitimate state interest test, which has been shied away from the Supreme Court of Lingle. But Lingle itself says we either use the absolute regulation, the regulatory action, is it deemed per se because it's a physical invasion? If not, is the regulation completely deprive the owner of all economic use? And if that doesn't fall into it, then we use Penn Central.
You're looking at deprivation of economic use. Does the placement of the lien deprive the owner of any economic use if the property was never offered for sale and there's no evidence that it impacted the value of the property?
So it could. But at this point, what happened is we're at the directed verdict stage of the trial court. And so the Court of Appeals was facing a directed verdict decision. And they followed this court's decision in Mayhew, which followed the analysis of Penn Central. And under those opinions and under those factors, the Court of Appeals correctly applied the law to the facts. The Court of Opinions, it literally goes A, B, C, and D. It follows the Penn Central standards exactly. They went through the analysis of the economic impact of the regulation of the property owner, which was to first compare the value taken from the property and compare to the value that remains, which incidentally, and ironically, I would point out that this court was one of the first courts to actually, I think, identify just jurisprudence of takings, because in 1885, in G.C.S.F. Railroad versus Fuller, although it's not necessarily a direct takings case against a municipality or a government, This court pointed out that in context of Article 1, Section 17, the idea of protecting private property when a railroad decided to build a railroad down St. Emmanuel Street in Houston, there was a private right of action based upon whether there was a diminution of value of whether that railroad hurt the property owner's property. And the court found that if there was a diminution of value, the property owners had the right to receive damages. And if the balancing test said that if the railroad in fact increased the value, they might not have any value at all.
But is there a difference between the investment bank, one of the parts of the Penn Central test is investment bank and reasonable investment bank expectations? Is there a difference in the lien here that was imposed versus tax liens, for example, in terms of what the owner's reasonable investment bank expectations are, that's separate from whether the particular tax or the particular lien here were imposed improperly?
Absolutely. And here's why. Because see, Mr. Schrock bought this property in 1993 for the purpose of rental. And the record is clear that, and the Court of Appeals found, that it was his expectation and his specific investment goal to purchase 2 or more rental properties annually for the foreseeable period of time over the next 10 to 15 to 20 years. It was his expectation and his investment goal to then, at some point in time, retire by then selling them off. He was going to rent them every year. And the record reflects that he continued to buy. He had as many as 20 or 30 rental properties. So when he then had, and at some point in time, for about 10 years, these tenants had delinquent water bills. He didn't know that. The record reflects clearly that he had every one of his tenants provide a lease when they went to the city to acquire water in the tenant's own name. The record reflects he had them provide the tenant sent the lease, and their water deposit was higher than it would have normally been for an owner-occupied request for service. The Court of Appeals then also found that, that was his primary expectation. His primary expectation was rental investment. So when Mr. Cuellar, in January of 2010, came in there to try and turn on his water service, and he was told that he would not be entitled to water because there had been a lien placed on the property 6 months earlier, in May of 2009. He had already contracted with Mr. Schrock for a leasehold lease. And at that point, when he could not obtain water service, that tenant vacated the property. At that specific point in time, that tenant left. And at that specific point in time, the regulation that had been imposed on this property, the regulation that the city of Baytown had on its books, actually had an economic impact on Mr. Schrock. Whether it's $1 or $1 million, I don't believe is a relevant factor. It had an economic impact because if Mr. Schrock had owned a $30 million office tower and had lost a tenant, and instead of losing $600 in rent, he had lost $600,000 in rent, we'd still be arguing the same legal position.
Why wouldn't we look at the economic impact as the amount of the lien? And then if there are consequences to not paying it and letting the utilities be turned off for years, that's a different story. This all could have been addressed by paying what the city said was due, $1,100 or $1,500, something like that. And isn't that the direct economic impact of what the city did, and then the rest is caused by the way Mr. Schrock decided to handle the situation?
Your Honor, I understand the appeal that the petitioner is trying to make to that argument, but I think that's a red herring because it wasn't just $1,500. What the record clearly reflects, though, is that when Mr. Schrock went to first pay the bill, it was approximately $1,500. And then was when it went up. It continued to go up, even though they told him that some of his tenant had paid down some of that amount. So imagine now for a moment that the lien, even though it should have been a finite amount, didn't change, even though there had been payment down on that amount. And then when he began to then make payment in full, the record clearly identifies, and the Court of Appeals found, that they told Mr. Schrock, okay, we now need to talk to you about your other 19 rental properties. So it's not just $1,500. It could have been as much as $30,000 of all these others, because now they were going to essentially extrapolate and
did he administratively appeal the improper assessment? And I don't, the lien, how many months was the lien in place?
almost 4 years.
4 years, okay, it's 48 months. Okay, so did he, in the administrative process, seek bereavement, seek removal of the lien, appeal the decision that he won in part but didn't win completely to the next stage of the administrative process? And why wouldn't the administrative process have provided a remedy for the improper application of this ordinance?
Your Honor, the record doesn't reflect anything about whether there was, in fact, an administrative process that would have been available to him. The record does not indicate that there indeed was some additional step he could have taken. I wish there were, but it's absent of those facts. It presumes that he could have done this. But I think the record does clearly indicate that there was bad faith on the part of the city. I do assert that. And I do believe that the character of the government action in this situation, where we have a city ordinance that is directly in conflict with state law, does go to the factors of the Penn Central standard. And the Court of Appeals found this. The Court of Appeals found material facts to support their decision. For example, the evidence was that the government illegitimately and in bad faith knew that the property itself was rental property. The Court of Appeals found in this record that the city knew this was rental property when they filed the lien. Mr. Schrock had even filed his declaration in satisfaction of the ordinance itself a month before the lien had even been filed. So,
for a reason that Mr. Schrock couldn't have by contract through a lease with his tenants have provided to maintain his investment-backed expectations by saying, holding on to a deposit, for example, to ensure that the bills did not remain unpaid. Couldn't he have just contracted to have the tenants pay him if it turned out that they didn't pay the city?
I don't know, Your Honor. The tenants are contracting with the city itself. It's a city utility. They're the ones that have to get the utility water in their own name. The record doesn't contain any information that I could use to answer your question. I do know that what the city has done in this situation, based upon this record, is that they were using this ordinance to clearly do what Penn Central and this court in Mayhew and have given direction on what is not right about unjust takings, which is the idea of putting the burden of the public's benefit on the backs of a few. Because what has happened here is that, as I pointed out and I was describing in Pennsylvania Coal versus Mayhew, is the benefit of the public to protect all of these homeowners from having their land and their homes fall into the earth from a sinkhole is to have the burden on the coal owners. It's the same thing, because what the city was doing is saying that if we can't collect from either mismanagement or misfortune the uncollected water bills, we're going to have a few individual property owners pay for all of those extra uncollected debts. They had an ordinance that allowed them to do that the lien itself is what happened. They used the lien to prevent from any new tenant from being able to turn on water at the property. And by doing that, the factors of the economic impact on the regulation of the property owner is what we have here now. So the evidence, there was evidence of material fact on the elements of the individual Penn Central factors. The economic impact to Mr. Schrock occurred when he lost his tenant. The Court of Appeals went down the line and found that he had purchased this home for $21,000. He had put money into the home. He had lost rent. And there's not an issue of, I see my time is about up. May I briefly finish my thought, Your Honor?
Finish your thought.
The issue about, he didn't abandon this property for 10 years. He was in the middle of litigation. And the irony is that the city of Baytown didn't even remove their lien until a couple of years after the litigation had been filed. For these reasons, Your Honor, I ask that the Court of Appeals decision be affirmed.
Any other questions? Thank you, Counsel. Killian, I believe you have 5 minutes.
Thank you, Your Honor. Just a few things I wanted to address that brought up. The first is whether Penn Central should apply here at all, and the city's position is that it shouldn't because this isn't a challenge to a land use regulation. If it is a challenge to a land use regulation and Penn Central were to apply, the question that Penn Central raises is whether overall the public should bear the burden of the regulatory action that was in place over the private landowner. It's a balancing test. It's a fact-sensitive balancing test that is undertaken. The court looks at the 3 factors and balances those factors, but also they're really looking at the reasonableness of what happened. What happened in this case was that Mr. Schrock abandoned his property and decided not to pay the bill and allowed his property to waste away.
If we go back in time, so the city amended its ordinance to comply in 2011?
Yes.
But didn't remove the lien until June of 2013? So what are we to make of the fact that the city brought itself into compliance but continued to pursue its lien or continued to have its lien in place for about 2 years?
Well, I think, Your Honor, the city, if it could go back, it might make some different decisions. And again, whether it made mistakes or not isn't really part of the analysis we're taking. As far as Carlson speaks to this and says allegations of mistake are just allegations of negligence. Yes, if the city could go back in time, it might do things a little bit differently, but ultimately they did remove the lien. They realized they had made a mistake. He never had to pay that lien. He did request services in 2012. The city provided services to him, and then he called and asked the city to turn them back off, and then he just left his property vacant and stayed. Another thing to touch on, as far as going back to Penn Central and the factors. So, as far as the economic impact goes, again, he didn't present evidence of an economic impact from the lien. The lien caused a $1,500 approximate burden on him. He could have paid that amount, and in fact, testified that he could have paid that amount, but he chose not to. Again, the city released the lien. Placing the lien is not unconstitutional. There's no dispute that he expected to use his property as rental property, but that goes to whether what he did was reasonable under the circumstances. It's certainly people, their property, they can use their property in a way that is reasonable with reasonable restrictions. And so the only reasonable expectation would have been for Mr. Schrock to use his property with the restrictions that were in place at the time. He doesn't have any reasonable expectation that he could use his property any way he wants to without restriction, and that goes to whether the land use regulation itself is a reasonable regulation. We don't have a land use regulation in this case, but if for a land use regulation, that is the question, whether the land use regulation itself is an unreasonable interference. The only reasonable expectation here would have been that he would incur a $1,500 charge that he might believe was improperly assessed against him, but it certainly wasn't reasonable for him to abandon his property and require the city to pay for all of the waste that he alleges occurred there.
Do you have a reasonable expectation, though, that a lien wouldn't be imposed in violation of state law?
I think that, again, whether the city made a mistake in passing its ordinance or enforcing its ordinance, those are all issues of mistake and negligence. And so
But I guess what I'm saying is it's not a situation of it was just a mistake applying this lien to them. This type of lien couldn't be applied to anybody under state law. The city didn't have the power to impose such a lien. It seems like that's a different situation from maybe they imposed a tax on some individual who wasn't supposed to pay it, but it was a valid tax.
I understand, and I'm almost out of time, so I'd like to just finish and answer your question. So whether an ordinance is invalid itself is not going to affect the takings analysis. You still would have to show that the regulatory action physically cause a physical interference or a regulatory interference, and that regulatory interference was unreasonable enough and severe enough to cause the public to bear the burden of that regulatory action. And again, in this case, the regulatory action is not a land use regulation. It was a utilities provision that imposed a lien on the property, which wasn't unconstitutional, and it would only reasonably cause a $1,500 fee, and the decision to not pay that fee and allow the property to waste away and to decide not to rent it for a number of years is really, shouldn't be having the public bear this burden of that decision. And it would be an unreasonable expectation under that situation.
Any other questions? Thank you, Ms. Gillian. Case is submitted and the court will take all their questions.
All rise.
Please be seated. We'll hear argument in 2517, U.S. Bank National Association against Others.
May it please the court. Mr. Crowdville will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, Chris Crowdville on behalf of the petitioners, U.S. Bank Association, U.S. Bank National Association, and joined by my colleague Adam Dunlop. In 2007, Your Honors, the Texas legislature took decisive action to cure the historic and reoccurring problem of default judgments against banks and other financial institutions in Texas by passing Section 17.028 of the Civil Practice and Remedies Code. Now, Section 17.028 was designed to end a practice that had evolved wherein a plaintiff suing a bank or financial institution would serve a bank officer, because under the prior law it was permissible to serve a bank for any bank officer in any branch. They would find a junior officer at an outlying branch and hope that they didn't timely relay the suit papers to the legal department back at headquarters, and thereby allowing an aggressive plaintiff's counsel to take a default judgment. Section 17.028 was designed by the legislature to end this practice by mandating that service of process on a bank or other financial institution be made up through its registered agent, or if the bank lacks a registered agent, through a branch president or branch manager at an office located within the state. So the legislature amended the Civil Practice and Remedies Code to establish a specific service scheme on banks, and on its face, that appears to be mandatory. We'll get to that text momentarily as to why I believe 17.028 to be the mandatory mode of service on banks and financial institutions in this state. But the goal of the legislation was to allow a bank to sleep well at night knowing it had a registered agent in the state of Texas to receive service of process and to put an end to the sorts of surprise default judgments that had characterized an earlier era of Texas law. Well, lawyers are nothing if not creative, and while 17.028 did solve the problem of service on junior officers in remote branches, a new problem has manifested itself. In this case and several others.
A new problem, Mr. Crowdville. I think what's now in the Estates Code is back from the 1960s originally, I think, when that provision was first enacted, and then it was reenacted in the Estates Code after 17.028 was passed. And also, it's my understanding that the legislation that added 17.028 repealed certain language in the Finance Code regarding service. So why shouldn't we presume, in light of that history, that the legislature intended to leave the requirements of the Estates Code in place?
Oh, Justice Busby, as an initial matter, you're quite correct that the language in the Estates Code dates from 1961, and again, an earlier era of Texas law, where out-of-state financial institutions were being allowed into the state for the purpose of serving as a trust or in other fiduciary capacities to estates. It is not a broad, general service statute of general applicability. That's where 17.028 comes in. And I think to answer your more fundamental question about the interplay between Section 505.004 of the Estates Code, because you're quite correct, the former probate code 105A has now been codified at Estates Code 505.004A. We have to start by engaging with the text of 17.028. And when we do that, I think we see a mandatory scheme. And I'll start with 17.028B, which starts with the first phrase. It gives us a clue that we're dealing with a mandatory scheme. It says, except as provided by subsection C. That means that a carve-out for subsection C, a limited carve-out for credit unions, which are obviously a special type, a different type of financial institution, in subsection C. So, except as provided in subsection C, subsection B is universally applicable. And it goes on to say, citation may be served on a financial institution by, and it lists the two provisions that I've already mentioned, service for a registered agent or service through a bank branch president or manager. I'm sure counsel opposite will, very capable lawyer, talk about may there. In an ideal world, I will concede I would rather have shall than may in that statute, but I don't think that liberates us from that introductory clause except as provided by subsection C, which indicates the mandatory nature of subsection B except for the carve-out. More fundamentally, and more importantly, the second indicia of the mandatory nature of 17.028 is found in subsection B. If citation has not been properly served as provided by this section, a financial institution may maintain an action to set aside the default judgment or any sanctions entered against the financial institution. This establishes a right that if service is not made pursuant to this section on a bank or other financial institution, that bank can seek a set-aside of that default judgment. Again,
if we agree with you about that, then why isn't service under Section 505.004, why isn't service on the appointed agent for service and process, rather, that was appointed under 505.004, service on a, quote, registered agent under B1 of 17.028?
Well, I think that gets a little more into the facts of this specific case rather than the broad rule of law and the interplay between the two statutes. But I'll take a shot at that, Your Honor. I think there's two things going on in the record related to U.S. Bank. First is found in Clerk's Record 75, which is a May 22nd, 2013 letter from the bank to the Secretary of State designating CT Corporation as the bank's registered agent for service of the process. This case is filed several years later, so this letter on May of 2013 well predates this case. So as of the filing of this case, and at all points relevant to this case, the Secretary of State was aware, and petitioner or respondent's counsel easily could have been aware of the identity of the registered agent for service of process in this state. And if you flip one page in the clerk's record to take a look at clerk's record page 76, there is a second letter in which the Secretary of State acknowledges the update of the address of the registered agent for service of process for U.S. Bank, which is CT Corporation, the company whose business is serving as a registered agent of service of process and accepting service of process for large companies like U.S. Bank in an effort to prevent exactly these sorts of default judgments.
So are you arguing that the Secretary of State should have also treated that as an update of the person that's been appointed under 505.004 to A2?
I am, Your Honor. I think there is adequate notice given to the Secretary of State. In this case, the bank made a good faith and reasonable effort to make clear that it had CT Corp as its registered agent for service of process, as many large companies and many large banks do. And the next hint that we get in the record that the Secretary of State should have been aware of this, and respondent's counsel should have been aware of this, is that Clerk's Record 73, which is the return of process, where the Secretary of State acknowledges that the suit papers sent on March 21st, 2017, so 4 years after the designation of CT Corp, was returned to sender to Philadelphia Presley on no such number, address unknown. So between the multiple designations of CT Corp as the registered agent for service of process, which is publicly available, and the return address unknown, no such number, when they attempted to serve the former registered agent, I think the bank behaved very reasonably and within the contemplation of the Texas Rules of Civil Procedure and the Civil Practice and Remedies Code. But again, Justice Busby, this is my point that 17.028 was designed to prevent exactly this sort of scenario and to allow a bank or other financial institution to sleep well at night knowing that it had properly appointed a designated agent for service of process in this state.
And I took that to be the argument for your brief, but which only presents a single issue, but I forgive me if I missed it, but I didn't understand from your brief that you were also arguing that the Secretary of State should have treated that designation as effective under 505.004A2. I thought the argument was that 505.004 does not apply, and rather 17.028 applies exclusively.
That is one argument we certainly make, Your Honor. I would say that there are three ways the court could reconcile these two statutes. The first way the court could reconcile those two statutes is what the Court of Appeals for El Paso did in the Bank of New York v. Chesapeake case, where it simply held, and that's now been followed by the Tyler Court of Appeals more recently in a supplemental authority letter that I've submitted to the court, where those two courts of appeals have ruled that 17.028 is the exclusive means of serving a financial institution under the Texas Civil Practice and Remedies Code under Texas law. The second way these two statutes could interplay is if there is a carve-out, just as there's a limited carve-out from 17.028B in subsection C, there's another carve-out for estate-related cases. 505.004A is in the estate code for a reason. That reason is it's not a generally applicable service statute. It's not meant for service in all scenarios. There's no estate.
Following up on that, does the Bank Act, by holding a deed of trust, does the bank act in a fiduciary capacity with respect to the mortgage debtor?
So the bank is here in a trustee capacity insofar as it is the trustee for a pool of investors who invested in these pooled mortgages. So that is, when the bank refers to itself as a trust, that's what the bank is referring to. But there's no underlying estate proceeding, Your Honor. There's no corpus delicti, if you will.
Well, I'm just trying to figure out vis-a-vis the plaintiff in this case, the mortgage debtor, is the bank acting in a fiduciary capacity on behalf of the mortgage debtor?
Your Honor, I'm going to defer to Mr. DeMond, if he's not an expert on that. There is no fiduciary relationship between the bank and the debtor.
Lots of Court of Appeals cases that say that the bank, as the holder of the deed of trust, doesn't act in a fiduciary capacity on behalf of the debtor.
Your Honor, you're absolutely correct. The fiduciary relationship is between the bank and the investors in this pool of securities. So there is not only no estate proceeding here, but no fiduciary relationship between these parties. So it's really taking a limited statute, which is designed for fiduciaries for estates, and trying to make it into a general purpose statute. It's the new way of making it end run around 17.028.
Except that 505.004 doesn't seem to limit itself to people in a fiduciary relationship. It just says action or proceeding related to a trust, estate, fund, or other matter. So doesn't this relate to a trust?
Justice Busby, we can't let that section become the exception that swallows the rule. And I'm afraid that's what that reading and what the reading from the Dallas Court of Appeals would do. Most of the actions banks take, many of the actions, are in a fiduciary or trustee or similar capacity. And 505.004, if given that reading and read with equal standing to 17.028, would swallow the rule.
So does that mean the bank would have to deposit certain assets in order that section of 505 would otherwise exempt it from depositing? I mean, that was the purpose of what's now in States Code Chapter 505 is you don't have to go through the owner's requirement of depositing a bunch of assets to be available for claims, but in turn you have to designate an agent. So if they don't have to designate an agent, do they then have to comply with those other provisions of the finance code?
Your Honor, I'll confess that goes a bit beyond the scope of the argument here in that there is no dispute.
That's the trade-off, though. That's what I'm getting to, is the trade-off was, okay, it's going to be easier to serve you, but we're not going to make you comply with all of these onerous requirements for doing business in Texas. And so, deposit of securities and that sort of thing. So I'm just wondering if you sort of have to take the bitter with the sweet on that.
Well, I think 17.028 envisions a simplified service scheme on financial institutions. My client, in this case, is undisputed at all times relevant to this proceeding, had a registered agent, and I'm willing to bet that virtually every out-of-state financial institution that does business in Texas has CT Corporation or a similar registered agent in reliance on 17.028. And to the extent that someone fails to designate a registered agent, then there's subsection B, part 2, which is go serve the branch manager, go serve the branch president. So it does not create a difficulty in serving out-of-state financial institutions. It actually creates, a elegantly simple process that they made an end run around in an effort to get a default judgment. It's a remarkable reversal of fortune to go from being on the cusp of foreclosure and defaulting on a mortgage to being out from under that mortgage and having a free house. And I see my time is up.
Any other questions? Thank you, Mr. Creditor.
Thank you.
From the respondent.
May it please the court, Mr. Harder will present argument for the respondent.
Mr. Chief Justice, may it please the court, thank you for the opportunity of hearing our thoughts this morning on this case. The issue presented by a U.S. bank who appears before the court not in its individual capacity, but as trustee for the Residential Asset Mortgage Products, Inc. Mortgage Asset-Backed Pass-Through Certificate Series 2005-EFC2. The question presented is, did the district court err by allowing service on U.S. Bank as trustee under the Estates Code instead of requiring service under the Civil Practice and Remedies Code, Chapter 17028? I would submit to the court that based on the analysis of the court below, Justice Whitehill's opinion in this case and Judge Fitzwater's opinion on the remand that is in the record, as well as cited in my brief, there's not an inconsistency between 17028 and 505004. When you examine the statutory schemes in both the Civil Practice and Remedies Code and in the Estates Code, when you examine the language, when you examine the legislative history, the conclusion that I think is mandated is the conclusion that was arrived at first by Judge Fitzwater, whose reasoning was adopted by the Second Court of Appeals in the NSL case, that was again adopted by the Fifth Court of Appeals in this case below. U.S. Bank in 1961 filed its application for authority to act as a foreign fiduciary with the Texas Secretary of State, pursuant to what was then the newly enacted Probate Code Section 105A. According to their paperwork, and that paperwork is before the court, it was made an exhibit to the original petition. The Secretary of State was irrevocably appointed as the registered agent for service of process in cases where U.S. Bank was being served and sued in its capacity as a fiduciary. In that designation,
is the plaintiff in this case a beneficiary of a trust or an estate?
No.
And so is the bank acting in a fiduciary capacity with respect to the plaintiff?
Not with respect to the plaintiff, but with respect to the holders of the securities. So with these mortgage-backed pools, you've got a depositor, originators of loans or holders of loans that put them into a trust and they transfer title to those loans to U.S. Bank. So U.S. Bank was acting as a fiduciary not with respect to Dennis Moss, but with respect to the certificate holders of the Residential Asset Products, Inc. Mortgage Trust, yada, yada, yada.
So when the probate code says it applies to proceedings limited to matters within the state to which the fiduciary is acting in a fiduciary capacity, is this a matter where the fiduciary capacity of the bank is at issue because it's not the beneficiary of the trust that's suing?
The importance of the fiduciary relationship here is that the bank is acting in fiduciary capacity as it is holding the securities, as it is holding the deeds of trust. The U.S. Bank owns the deed of trust executed by Dennis Moss, but it doesn't own it for its own behalf. It owns it on behalf of the certificate holders of this particular trust. So when Dennis Moss filed his lawsuit contesting the enforceability of the deed of trust, naming the holder of the deed of trust, which was U.S. Bank as trustee, U.S. Bank was not acting as holder of the deed of trust on its own behalf. It was acting on behalf of the registered certificate holders of this mortgage-backed trust. And so therefore, when you look into the The language of 505.004, as Justice Busby was noting, service on the Secretary of State as registered agent for the foreign fiduciary is proper when the suit is regarding various things, including the other matters. And so when you review the analysis of the Second Court of Appeals in the NSL case, one of the arguments made by Bank of New York in that case was that the estates code doesn't apply because very similar kind of fact pattern contesting the enforceability of the deed of trust. Bank of New York was arguing the estates code didn't apply because this has got nothing to do with some sort of a traditional probate or estates matter. And the Second Court of Appeals went through the analysis of the language of the statute and focused on the other matters language to conclude that you can't draw the estates code so narrowly because then what you're doing is vitiating the other matters portion of that.
But the other matters is limited to those with respect to which the fiduciary is acting in a fiduciary capacity.
Well, that's correct.
Is that what the Court of Appeals in El Paso was getting at?
Well, I think what the Court of Appeals in El Paso was concluding without really analyzing the language of the statutes was that because in that case it wasn't a probate type of a matter where you were dealing with a testamentary trust or a living trust or that kind of a trust, it just doesn't apply. And so you have a difference of opinion between the Eighth Court in that case and between the Second and the Fifth Courts and Judge Fitzwater in these other cases. I would suggest, Your Honor, that the analysis of the Eighth Court is just wrong, and that the analysis in the MSL case, the analysis in Justice Whitehill's opinion in this case, the analysis that Judge Fitzwater had in the remand order is a much more thorough and cogent analysis, and I think it's supported by just the language of the statutes and applying this court's rules of statutory construction. Because there's so Judge Fitzwater, I think, was one of the first to really address this in his opinion, and his conclusion was that you've got 17028 and you've got the Probate Code 505, and that they're not mutually inconsistent. And his conclusion was that because the Secretary of State was the registered agent for U.S. Bank, service upon the registered agent of U.S. Bank being the Secretary of State was service that was consistent with 17028. So even if you were to say 17028 is the quote-unquote exclusive manner of service, which I disagree that it is because I think may means may, it doesn't mean shall, but that's another topic of conversation, that because the Secretary of State is the registered agent for service and process, then therefore service on the Secretary of State in this case was in fact consistent with 17028. So in looking at the history of these statutes, you've got Probate Code Section 105A, of course, was enacted in 1961. 17028 was enacted, I believe, in 2007. 105A was then recodified as the Estates Code 2 years later, went into effect a few years after that. But this court has always said that it will presume that the legislature is aware of prior law as it creates new law or amends old law to create new provisions. I would suggest that if the legislature wanted to make it the exclusive way to serve any kind of a bank in any kind of a capacity, that it be served according to the quote-unquote registered agent, and that 505 would not apply or 105A would not apply, then they would have said that. And that never happened.
Doesn't D say that? 17.028D. Saying that if citation hasn't been properly served as provided by this section, the financial institution can send the judgment aside.
I don't think that has any applicability to the analysis of whether service is proper by serving the Secretary of State or not. I would also suggest that in a sense that provision is somewhat redundant, because if any party suffers a default judgment and believes that it was improperly served with process, It has the remedy first of a restricted appeal for the first 6 months afterwards, and then a bill of review afterwards. And even though a bill of review has a 4-year statute of limitations, if the issue is no service at all and a violation of due process, a default judgment could be collaterally attacked at any time. So I really don't think that subpart D has any effect on this, because if, in fact, let's say according to counsel's argument, we should have served CT Corporation as the registered agent of U.S. Bank, well, then they have the remedy, of course, and the remedy is, in this case right now, the bill of review. And that leads me to another point, which I'd like to make here, because counsel made this point, and he didn't make it in his brief, but he did make it an argument, and the court picked up on that. So, between 1961 and 2003, the designee for U.S. Bank under the probate code filing was Kristen Strong of 350 or 450 North Robert Street, St. Paul, Minnesota. That did not actually change until, I think, 2016, 17, 18. I'm not sure exactly when the designation changed. What they did do in 2013 was they changed the registered agent for service of process. There's a difference between a registered agent for service of process and the designee that the Secretary of State looks to when trying to decide where do I send the citation and petition once I receive this on behalf of a foreign fiduciary corporation. So what CT Corporation said to the Secretary of State was, if we get sued, okay, our registered agent is CT Corporation. So if I want to sue U.S. Bank in its individual capacity for whatever reason, whether it's breach of contract or it holds a deed of trust that I want to challenge in its individual capacity, then I have it in the public record that CT Corporation is their agent for service of process. That's completely different from the estates code filing, because in the estates code filing, the registered agent irrevocably is the Secretary of State, and it's a two-step process, the second step being designating the person to whom process is to be forwarded. This is a point that was raised actually in the federal district court in the remand hearing, and what Judge Fitzwater said, and I believe he's absolutely correct in this, is that there's a difference between the two. And that if U.S. Bank wanted to change its designation, it certainly has the capacity and the know-how, it certainly has the legal help to be able to file that particular document that says whenever we're sued as a foreign fiduciary, this is our designee. And in fact, they ultimately did do that a few years ago. It's a separate filing, it's a separate purpose, it's a separate person altogether. And I think to say that the fact that they changed their registered agent from Kristen Strong to CT Corp for purposes of registered agent appointment is sufficient to change their designee. It's just disingenuous, and it flies in the face of the statutory provisions. So I think there's no merit whatsoever to that argument. I think the court has the benefit of reasoned opinions, besides those of Mr. Cradiville and myself, as to what's the proper reading of these statutes. I don't know that I could do a better job than Justice Whitehill or Judge Fitzwater or the Second District Court of Appeals in the NSL case in explaining why it is that service under the estates code in this case was absolutely appropriate. The cases cited by the petitioner, I think, are generally all easily distinguishable with the exception of the Chesapeake case, the Eighth Court of Appeals case. The other cases have to do with situations where there were pleading deficiencies when the long-arm statute was being invoked, and it has nothing at all to do with the issue that's before the court this morning. The case in the Eighth Court of Appeals is distinguishable in the facts, and I think it's distinguishable in terms of the analysis as well in a couple of important respects. So in that particular case, the estates code was not invoked until the case got on appeal. In the trial court, I believe the allegations were that the registered agent for the defendant is this out-of-state person, so we want to serve the Secretary of State, we'll then send it to the out-of-state person because they didn't have a Texas designated registered agent. So mistakes were made in the way the pleadings were drawn, and I think the conclusion of the Court of Appeals was probably correct. Service was inadequate. But the reasoning on the Estates Code was, I think, completely wrong. The Court of Appeals completely turned around the Code Construction Act and redefined may to mean shall, and it did not go through any kind of a rigorous analysis of the language of the Estates Code or the interplay between the Estates Code and the Civil Practice and Remedies Code as to why it is or is not the service via the Estates Code is proper. But in any event, they didn't even need to reach that in order to reach their opinion, because the pleadings in that case did not invoke the Estates Code whatsoever. This was an argument that was made just on appeal as an alternate way of justifying service by serving the Secretary of State to send the paperwork to the otherwise designated registered agent, who was, I believe, in the state of New York. So I think all the authorities that are cited by petitioner in this case are either completely inapt or distinguishable, but again, to the extent that the Eighth Court of Appeals provides some authority for their position, I think that the opinion that you have in the NSL case followed by the court below in this case is a much more sounding reason to be. And with that, if there's no questions, I'll be happy to give the court back to balance my time.
Any other questions? Thank you, Mr. Murphy.
Thank you very much, John.
Mr. Crawford, you have 5 minutes.
May it please the court. We cannot allow the exception to swallow the rule, and that is precisely the relief that respondent received by this end run around 17.028 using the estate code. I don't want this court to lose the forest for the trees. As you all are well aware, Texas law abhors a default judgment, favors adjudication on the merits, and disfavors litigation results based on technicalities. Here, as you've just heard counsel present, his best argument is the narrowest of technicalities. First, that the estate code applies to this non-estate case, where there is...
The whole nature of service is technical, so why don't we have to look at what the legislature has provided as far as different methods of service and decide which ones apply or don't?
Ultimately, Justice Busby, I agree that is the task before this court, and I think when the court engages with the text of 17.028, as I discussed in my opening, as well as with the legislative history laid out very nicely by the El Paso Court of Appeals in the Chesapeake case, it becomes clear that both in its text and in its legislative history, 17.028 was designed to cure a problem. It cured that problem. Very, very clever, very capable plaintiffs' counsel have made an end run around it using the estate code.
Well, I mean, there's no need to cast aspersions on anybody here. If they're using the statute in good faith, then we just need to decide whether it applies.
I mentioned as a compliment, actually, Your Honor, and capable counsel. I suggested in my opening 3 ways that this interplay can work. And I think I got 2 of the 3 out. The first is the flat-out exclusivity of 17.028, which is the way the Tyler Court has gone, and which I think arguably the Chesapeake Court out of El Paso has gone as well. The second potential interplay would be that 505.004 applies to fiduciary cases where there is an alleged fiduciary relationship between the parties or involving an estate. That's what's absent here. There is no estate or anything that would trigger the estates code. This is a pool of mortgages that investors invest in. That device didn't exist in 1961, and I don't think that's the fiduciary relationship contemplated by the estates code. So limit 505.004 to the estates code. The third...
Where does it say, though, in 505.004.2 that the action has to be for breach of the fiduciary relationship?
Your Honor, I'll concede that I don't think it's in there in the text. If you look at Clerk's Record 65, which is the probate code filing, that's the title of the document, that U.S. Bank made back in 2001 when it gave this initial designation. The language tracks the statute and says something to the effect of may be served in any action or proceeding relating to any trust, estate, fund, or other matter within this state with respect to which such corporate fiduciary is acting in any fiduciary capacity.
I'm sorry, I interrupted you. I wanted to hear your third point.
The third one would be to allow the exception to swallow the rule and to give equal status in all cases where there is any sort of fiduciary relationship, any sort of trustee relationship, even if it's not between the parties, even if it's not alleged in the pleadings, to 505.004A. And that's the result I urge this court to avoid because it will require legislative correction. Just as the past tradition of taking default judgments against banks and other financial institutions required legislative correction, if this court does not follow what the El Paso court has done in Chesapeake, what the Tyler court has done in Deutsche Bank, and the statutory construction that I've suggested for 17.028 as an exclusive means of service, at least outside of narrow fiduciary cases, then this sort of thing where there are strategic end runs and strategic default judgments taken will unfortunately continue and will fly in the face of the well-established principle that Texas courts abhor default judgments. U.S. Bank simply wants its day in court. It's ready, willing, and able to defend against a meritless lawsuit.
Any other questions? Thank you, Mr. Crowder. The case is submitted. That concludes the arguments in the cases set for this morning.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.